Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'm going to do a video based on a request from a viewer. They wanted to know if they could do a writ of mandate on a U visa that's been pending since 2015 and has not yet been adjudicated. So first, let me tell you what a writ of mandate is, what it does, and what it's used for. Now, a writ of mandate is filed in federal court, and essentially the bottom line of what it does is it says, look, the administrative agency is supposed to have made a decision on my particular case. It's been a long time. They haven't done it. Could you, the judge, force them to make the decision? Okay, that's the bottom line of what the writ of mandate does. The writ of mandate does not say force them to make a yes decision. It doesn't say force them to make a no decision. It just says force them to make a decision. So in many cases, when doing the writ of mandate, uh, you first have to send a request to the agency, specifying how long you've waited, what the situation is, that you'd like them to make a decision, and then gently let them know that a writ of mandate will be filed if they don't make a decision. And so normally when my firm files writs of mandate, the interesting part is 95% of them will settle before the first court date. That's just the reality. Um, Settle meaning a decision will come before the first court date. All of a sudden everything works out well, and they can make the decision. But part of the reason why I have such that high statistic there is I won't file a writ of mandate if I basically know it's not going to go the whole way, if it's not a winnable writ of mandate. And there's lots of immigration petitions where it's more on the gray line as to whether to file or not. But with a writ of mandate, you have to have a strong case in order to do it. So, first things first, you have to look at the merits of what it is that you're filing and see if there's a reasonable good chance that you would win anyways. So let's say with this U visa, let's just pretend that it was just a robbery. And I don't mean to minimize robberies, but for U visa purposes, let's say it was just a robbery. There was no weapon, there was no assault, there was no battery, just a robbery. And let's say that you, the victim, weren't even there when, for example, your house was robbed, and then you file a U visa saying you're a victim of crime. Well, just without knowing anything about the U visa, that's a surefire loser. Okay, you're never going to win that case. Now, if you file a writ of mandate on a case like that, that has weak facts, and that you certainly are not going to win, that would be a waste of your money, of time, of the court's time, of everything to do the writ of mandate, because all you're doing is rushing things along for immigration to say no. And they'll do that. They'll comply with the order if it's given, and they'll just say no. So that's the first thing. You have to look and determine the merits of your case. So let's say that, if I change the facts a little bit, let's say, on the U visa case, you were a victim of robbery, but the guy took a gun out and beat you over the head before you gave him the cash from the cash register. Okay, and you had to go to the hospital, and you had to get stitches, and you had to give the report to the police and so forth. Well, in that case, it's a very good U visa case. I mean, unfortunately were more of a victim, but it's a very good U visa case. So on that basis, the writ of mandate would be at least the first prong that I look at to determine whether to file a writ of mandate would be doable, because it's a good case. There's a reasonable chance that you would win on the merits and that it would go forward. And if forced to make a decision, that decision would hopefully be yes, based on the facts of that case. So that's the first thing. Now, the second thing, which is equally important, is you have to look at what is reasonable for time for them the administrative agency, which in this case would be USCIS, to make a decision. Okay, if it is within that reasonable time, then the writ of mandate will fail, because all they have to do is argue why it's reasonable, why it's not taking longer than usual, why they're complying with the statutory requirements, and the writ of mandate will not go forward. It will fail, and you won't get the order for them to make a decision. So let's look at the facts, at least as of what I was given of this case. You have a case that was filed in 2015, a U visa case, and it has not yet been adjudicated. So it's been about 4 years, okay, between 3 and 4 years, depending. So the question is whether or not that is an excessively long time, whether or not USCIS is violating its duty to make a decision in a reasonable time, and whether or not a writ of mandate would force them to make the decision. Well, if we look at the U visa regulations, they issue 10,000 visas per year. Okay, now this may sound like a lot, but unfortunately in America there's lots of victims of crime. So what's been happening is year after year after year, it's been backlogged. So for example, let's say that, in the first year, instead of receiving 10,000 applications, they received 20,000 applications. That means that 10,000 applications have to be put over to the next year before they can even be adjudicated, because it's past the amount that were allotted. And then let's say the second year, there's 30,000 applications. Well, you have to add the extra 20,000 on the second year plus the extra 10,000 on the first year, giving you 30,000 extra, so it even gets put over more. So that's the bottom line of what's been happening. So the number of U visas filed far exceeds the number available, and each year it gets farther and farther behind. And right now it is taking around 4 years for them to get to the case, to adjudicate it, not because they haven't had time, but because it's just not within the 10,000 per year that allows them to adjudicate at that time. Why should they adjudicate a case 3 years ago if they really can't issue it for another 4 years? Okay, that just doesn't make sense. So they being immigration, will easily be able to go into federal court and say, look, the backlog is 52,721 U visas. The typical time now is at least 4 years before it becomes current. This particular U visa case, the one that I'm doing the video for, is only 3.5, 4 years old. So it means that it's coming up right now for us to adjudicate, and it's timely based on the facts of what's happening in immigration. So given my explanation, at the present time, I would not file a writ of mandate for your case, because it is just getting to the point where legally it's waited long enough that it will be current for them to be able to adjudicate it. Now, let's say that one more year passes. Let's say it's the 5th year, and clearly they have already adjudicated a bunch of cases that are 4 years old. Well, then in that case, yes, it would be time to file the writ of mandate. But until that time, right now, I wouldn't do it. I'd wait another year. So hopefully this has cleared up some misconceptions of the writ of mandate, has made it a little clearer when you should file a writ of mandate, and has allowed you to understand the principles behind the writ of mandate. So if you like the video, click like, subscribe. Also, do feel free to send me your requests on videos you'd like me to make to clear up some other issues. I'll be happy to do so. More on the coming videos.